Talk 1010.
Had a very interesting, I thought, discussion with Lindsay Van Stone, one of our reporters, producers. Our program director, Mike Ben Dixon, weighed in at the end with some good calls. Good conversation the last half hour, the previous half hour of the show, on whether or not police officers should be just pulling you over randomly, because that happened to Lindsay this morning as she was coming in here 4 o'clock in the morning. Police officer pulled her over apparently because he realized after running the plates that she was from Barrie. And here's a woman by herself from Barrie in Toronto at 4 in the morning. So he basically just pulled over to say, what are you doing? What are the legalities of all of that? Edward Prutschi of Adler, Bertensky, Prutschi, Schickman Criminal Lawyers, Toronto, joins me now. Edward, good morning.
Good morning, Jerry.
You just take on a new partner?
We did add a new partner, former associate, now a partner.
All right, because you've been on before a number of times, which we really appreciate. And I thought, wait a minute, the name got longer of the firm here.
We're just making it tougher on you.
Okay, keep adding members till you look like a phone book. Partners. Okay, so what is the legality here? Is a police officer actually allowed to just pull you over anytime he or she feels like it?
So it's a bit of a yes and no. I mean, the reality is that police are not permitted to make completely groundless random stops, other than in the case of ride spot checks that are sort of set up for a specific purpose. But the practical implications are that through the Highway Traffic Act and our impaired driving legislation, there's virtually nothing that a police officer needs to do in order to justify a stop, because all they have to say is that they're pulling you over for the purposes of either checking sobriety or compliance with sort of roadworthiness of the vehicle or roadworthiness of the driver. And obviously those are extraordinarily broad categories. So an officer doesn't have to sort of see you with your seatbelt off to say, you know what, I'm going to stop that car and just make sure everybody's wearing a seatbelt. And in the case that was described by your producer, it just sounds like a situation of the officer giving perhaps an improper reason when, in fact, he could have simply relied on saying, I just wanted to make sure everybody was sober and safe. And that would have justified it.
All right. So essentially they don't need justification. In practicality, they don't need justification.
That's right.
Yeah. Now, what about running your plate?
Well, so running your plate is something that officers do very consistently, and there are debates within the law as to whether or not that in and of itself constitutes a search and seizure. I think most often you're going to find that the law falls on the side of the officers there, where if they've got a hunch, they can at the very least run the plate on their computer and see sort of what comes up. And so in the circumstance, again, that you described, the officer gets sort of a very intangible sense of suspicion because he sees a woman alone from Barrie in Toronto. I don't know what particularly is suspicious about that, but decides to pull her over. I mean, the short answer is, in terms of implications, it's bothersome, obviously, right? But it probably results in maybe a 2-minute delay before your producer ends up getting to work in any event. Where it would run into some difficulties if it turns out that she was, in fact, committing a criminal offense that the officer otherwise wouldn't have known about. Then the justification for the stop becomes very different, right? So if he starts rummaging through your trunk or wanting to see what's inside your purse and you've been stopped for no reason, and he can't articulate a good reason for it, there may be a situation in which that now comes into play at your trial in terms of exclusion of evidence. But there's really no redress when, after 30 seconds or a minute, the officer says, all right, just checked everything out, you're good to go.
All right, so the reason can be cast as, very broadly, as you said, just wanted to make sure you weren't a drunk driver.
Right.
If all of a sudden the officer says, I want to check your purse, you have the right to say, what's your reason? You don't have a reason to check my purse.
That's correct, and that obviously changes things very dramatically, because it's no longer a question of doing just a spot check for sobriety or checking on the roadworthiness of the vehicle. If the officer's actually searching the vehicle, whether that's searching occupants or searching in sort of the glove box, under the chairs, in the trunk, this we see all the time in so-called random stops that then exceed their limitations, and the officer finds a gun or drugs or some other improper things in the car, then you've got a very real claim for exclusion of evidence, because that should not have been part of the search unless the officer had really good reasons in advance for making that stop and for making that search.
Yeah, and would have to articulate in court then to the judge, here's why I felt it necessary to go further and check the purse.
Exactly.
I don't know what that reason would be.
Well, it would be very difficult, frankly, for an officer to justify that unless he had information in advance that this was a person who had been involved, for example, in a robbery and was holding something in the purse, or he could see, there's a plain view doctrine, so if he can see something sticking out of the purse that creates suspicion, officers will often try to cast their actions in a sort of self-protective way where they say, I was concerned for my own safety, and so I conducted a pat-down search, and then I felt something unusual, and so they go further from there, or they'll claim that they smell marijuana in the vehicle and want to conduct a more detailed search. And I mean, this is the bread and butter of criminal trials every day in the courts, where one starts to question how ingenuous the officer is being about what he did or didn't see and how he justifies a search after the fact.
Yeah, there's a story out of British Columbia right now about a woman. She's 82 years old, and the RCMP attempted 15 times to get a breath sample from her and then charged her for failing to blow. She's able to prove medically, because she went right to a doctor afterward, that she was sober, and not only that she has lung problems and actually can't blow in the thing, but they won't give her license back.
Yeah, I saw that one this morning, and it's one of those rare circumstances where I think the public may well actually feel a degree of sympathy for a person charged with refused breath sample. I know in Ontario, the only reason you can get out of the automatic suspension periods that come from the Highway Traffic Act for being charged with that kind of offense are either you weren't the person who's actually been issued the notice, so it's a mistaken identity issue, or you can prove that you were medically unable to blow. So I don't know whether that applies, frankly, on the British Columbia provisions, but it strikes me as she may well be in that small category of people who are just physically incapable of having provided that sample. And she goes off on her own and gets a blood sample, which the police are entitled to do, but almost never take that step. And that proves, in fact, that she wasn't intoxicated.
Yeah, but she's still fighting a fight, and she doesn't have the breath to fight the fight.
Literally or figuratively.
Yeah, and, look, I support the police. You support the police. We want the streets to be safe. I don't want drunks out there. I'd like to see drunk driving treated more seriously, but I do find it disturbing on some level that just because you happen to be the person who's there at 4 o'clock in the morning when the police officer doesn't apparently have anything else to do, they'll just pull you over.
Well, look, I know where you stand on that, Jerry, and you know where I stand. And none of us are pro-crime, regardless of how one wants to cast what the proper authorities of police ought to be. But you have to remember that the broader we cast the net for police and the easier we make it for police to conduct searches of people and to conduct investigations and to question people, the reality is that the bigger that net gets, the more likely it becomes that it's going to inadvertently pick up some innocent people. And so it's a very delicate balancing that we have to do, and it's part of everybody in the criminal justice system to make a conscious decision through our politicians and through our public requests that we decide, should we tighten things up, knowing that means some more guilty people are going to escape the net, but it means that we're going to pick up fewer of the innocent. So it's really a public policy question, but there's no way to get it all right all the time.
Edward Prutschi with Adler, Batinsky, Prutschi, and Schickman. Am I pronouncing that last one correctly?
You are.
All right, criminal lawyers in Toronto. It's always good to have you. Thank you.
Thanks, Jerry.